Just to begin this video, I'm going to do a little bit of housekeeping, and it's concerning the word scission, or that's how I have always pronounced it, just because it related closely to the idea of being seized and scission. But I've looked the word up and thought I'd listen to the pronunciation, and the common pronunciation of the word before I would pronounce as scission is actually season. And if you're in the UK, it would be scission. So if you might hear me say scission still, just remember it's the same word as what is commonly referred to as season. Now, before I continue, I want to say that I love how the script came together, so I hope that you will take as much enjoyment of learning what it has to say as I had learned from writing it and then rereading and of course making the amendments so it would flow better, in as much giving us better detail as to what the different estates are, and of course then leading us into the Settle Land Act 1925, which is essentially the entire purpose of this English law series. So it begins, or as I write, it is prudent, and so I was reminded by another of its importance, to perhaps mention that the two ways in which land is transferred today is either through the laws of inheritance in the common law and those through purchase. The laws of inheritance in the common law does not entertain the future interests of the heir until the subsequent estate held in the predecessor is pronounced dead. The illegal estate subject to these laws was through the natural termination surrounding the purpose of the estate itself. The estate is an estate of limitation, as it is confined within inheritance law and so controlled through rights of particular heirs, mainly bloodlines and male primogeniture. As for purchase, we know from the Statute of Uses 1535 was the introduction of the right to convey the entirety of estate held by the Cestui use, which before was only an equitable interest and so governed under the Chancery Courts, to now be of notice as a legal estate relative to those interests in common law. This, for the first time, allowed the Cestui use the right to now control a right of transfer through registered deed, whereby before a conveyance was done through the often cumbersome livery of season. Livery of season, as we have learned in past videos, was before necessary in order for a transfer of this type of common law estate into another, and was to be lawfully not considered a full right to then hold season in the transferee, meaning holding the entire power of this legal title before held in the transferor. Now, when we then transfer the legal estate into a trust, the laws of inheritance are not the same laws carried over into equity, for obvious reasons, as we are now affecting a completely different right to an estate interest, namely a different subject matter. These inheritance laws under a trust are often referred to as probate laws, but probate does not become inclusive of all inheritance rules. As for purchase, is the same, as this is first a legal estate created under an equitable interest, so not a settlement immediately subject to the common law, and so not first executed through the Statute of Uses 1535. And so, this type of estate is no longer the legal estate held in the common law, and so thereby not subject to those same limitations offered through the laws of inheritance, nor do they entertain those rights of possession. It might also be of interest to get our heads around the difference between the concept of season versus possession, as the system today often refers to them being of the same concept, but they were before distinct concepts. As discussed by Bora Laskin, a law professor at the University of Toronto and former appeal court judge of the Supreme Court of Ontario, he offers a distinction between the two concepts. He says essentially that season became more distinct in its meaning versus possession when it referred to freehold versus non-freehold estates, to which the latter was construed to be a chattel interest. Important note, chattel interest referring to land were an interest created through the Roman Church. Now, back to the text. The origins of the beginning of the feudal tenures were originally based on the quality of the state, meaning essentially the tenure was directly affected through one's status, to which then one was now seized thereof. And so one was seized in possession of this particular state interest in land called season. Note, status and estate were interchangeable terms, and this is still relative by today's standards. Let's continue. Back to my text. Whereas possession evolved from the quantity of the estate, a life or term, in example, as opposed to immediate status. And so tenants under lords, those who held in possession of non-freehold estates, like village, interest, and copyholds, were said to be in possession since they did not have season of the common law freehold, which was held by the lord. So I can feel my throat not being a bit dry, so I should have grabbed some water before I did the discussion. So I might be a little more squeaky than originally, and that's not because I'm going through puberty or anything. Anyways, there's a point of interest. This non-freehold estate came in under the concept of chattel interest, as previously mentioned, as they were not the common law title itself, but a different interest annexed to the land. Alaskan right, season, was aptly described as the quality of possession of a freehold estate or the root of a proprietary interest in a freehold. See Maitland, The Mystery of Season, 1886, unquote. This aforementioned overview is not to be then ossified in absolute terms, since over time new ownership rights evolved, and so season is now expanded to incorporate not just the common law titles, but now one can have a freehold concerning an equitable interest, which was before thought as merely a chattel interest, as we've already described, during the feudal land tenure system, and so these before chattel interests can now be construed to be held also in season. Even though each citizen under government is holding legally a third level right to the use of land, that interest is construed to be held in season concerning this type of state interest, whereby possession to the land itself can be held currently by another, such as a leasee, who is without season of this legal title, but has possession of a leasehold right against another through a contractual arrangement, while in possession of the land itself. Examples provided by Mr. Alaskan are as such. A is holding in fee simple, leases to B for years. B has possession, but A still retains season, although B is the de facto person on the land itself. Or, through the development of the doctrine of season, there was also the case where A was held in fee, granted B an estate for life. B then had rights to a freehold estate for life and said to now be in season, even though A still had feudal right to the states, which was old homage, fealty, and the like. Lawyers of the feudal time would then say that A was seized of these rights. This confusion was explained through qualifying that A was said to be seized in his services, whereas B was recognized to be seized in domain. Now, the word reads demence because it is spelled D-E-M-E-N-S-E, but is pronounced domain. Or, in another case, whereby possession of land was held by a party who did not have season, for instance, A held an estate in fee or life and a right to rent of B's land, who held possession, A was said to be seized of the rent, so as to have a right to this action against B if B created a tortious action against the rent agreement, which is separated from A's before right of entry that allows recovery of possession of the land itself for a condition broken, as an example. And so this right of entry originates from the original contract agreement and would be a separate action than the right to recovery of rent. Then there is another consideration of cession through the concept of dissession or decision or dissecine, which is pronounced in the UK, whereby one with cession is wrongfully ousted by a subsequent act of the one who's holding possession, or someone enters upon the land before the estate was transferred through the loss of inheritance. Both actions of this cession were to divest cession in the original holder so as to vest a tortious cession in another, such as party B from our above examples. Sometimes the decision would end up overreaching the original right of reversion in A. And so not only is A divested of cession, but he also lost the right to reversion. And so he had to exercise some other actions such as right of entry or right of action, which were dependent upon the time limitation allowed by law against the deceiver. At this moment, we will not descend from here into this particular topic of decision, but rather to next state as a careful reminder about the importance of making sure we are always speaking to the appropriate subject matter so as to give power to a judge to effect the appropriate remedy. It is also of note, those administrating under territorial laws concurrently, and so govern the second and third level use to land, are concerned with the dominion interest, which is the men's interest, as opposed to what was before construed to be held in season for service under the common law. We are only ever wanting to speak, and so are only interested in the return of season concerning the common law freehold, whereas the trustees have this interest in possession currently through an operation of law, and not by an act of parties, who hold this legal estate during our immediate life, and then I would surmise will continue to hold for up to 21 years after our physical death. Again, I'm not wanting to develop a discussion concerning this either, as to what happens to our legal estate after our physical life ceases. Currently, not a matter of this English law series. Okay, so we are now leading up to the warranty concerning our right to vest this legal estate created through our life, within the capacity of a tenant for life discussed in the Settled Land Act 1925, and so gaining this scission, or season, which is not subject to a trust. I'll stop here to make this short and continue on with the subject in the next video. Remember to free will click on the like button if this aligns with your feelings and your understandings, and if not described, please do so, as no one else is speaking to the right to your legal estate other than those I know. And thank you to those who have been so kind and donated to this content. Glad you're finding your way back to your true freedom. And with that, thank you for listening and learning.